The Court of Appeal item for the 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Judge, presiding. All persons having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to a session of oral argument with the 5th District Court of Appeal. As our marshal indicated, I'm Judge Lambert. I'll be presiding over the cases we have this morning. We're pleased to be here in Marion County. We come here annually, and actually this is the same panel that was here last year for oral argument here in Marion County. But we like to visit with the counties within our jurisdiction so that you have a chance to see what it is that we do if you choose to see what we do. We are pleased today to have some students from Forest High School and their teacher, Ms. Carr, attending today. What we do in these type of law day things, so the attorneys are aware, when we're done with each case, we give the students, or actually I guess anybody in the audience if they want to, but the students a chance to ask questions about anything that they're interested about pertaining to the law or lawyers. So we typically ask the lawyers themselves to, tell a little bit about themselves to the students and to stay after for a little bit to participate in any questions. It doesn't last too long. And we don't talk about who wins or loses, but they can ask you about general things about your practice of law, how you got here, things of that nature, and ask us anything that they want to as well. We preliminarily say if you have any type of electronic devices, cell phones or what have you, we ask you to either turn those off or put them in the mute position so that they don't inadvertently go off during the course of the oral argument that might interfere with the attorneys or with the court's questioning. We have 3 cases today on the docket. Each side will have 20 minutes to argue. I will give the appellant a 5-minute default time for rebuttal if you want to use that or not, or if you want to have less time reserved. There will be something that the yellow light will come on when you get into your rebuttal time. You can continue on if you choose, or you can stop whenever you want. The red light will come on and start flashing when you've exhausted your 20 minutes. So with that, we call the first case. It's 23-1060, Hernando County, Florida versus the Hernando County Fair Association, Inc. Counsel, are you ready?
Thank you, Your Honors. And I'd like to reserve 4 minutes of rebuttal time.
All right. There you go.
And may it please the court.
Yes, sir, go ahead.
My name is Kyle Benda. I'm an assistant county attorney for Hernando County, and I'm here on behalf of the appellant. Today I'm going to be making 3 primary arguments. The first argument is that it was an abuse of discretion for the trial court to dismiss the complaint with prejudice after the first substantive challenge on the merits of the case. Second primary argument is that it was inappropriate for the trial court to rule on a statute of limitations defense in a motion to dismiss. And the third primary argument is that it was error for the trial court to hold that the Fair Association's breach of contract was not a continuing breach. In relation to the dismissal of the complaint with prejudice, this court has ruled no less than 11 times that it's an abuse of discretion for failure to allow at least one opportunity to amend a complaint. And I can list off those case sites, or I have a demonstrative exhibit if Your Honors would prefer to see that, and I can provide it to opposing counsel with each of the citations.
I don't think we need a demonstrative.
Okay.
So, unless amendment would be futile.
Yes, Your Honor. So it's an abuse of discretion to dismiss a complaint with prejudice unless either the privilege to abuse has been abused.
Well, that's not an issue in this case.
Correct, Your Honor.
Futility is the issue in this case.
Yes, Your Honor. And the amendment of the complaint is not futile because Either additional facts could be pled or alternative legal theories could be pled to avoid the statute of limitations defense. In relation to the facts that could be pled differently, for example, if the Fair Association did in fact create a master plan in 2008, but then subsequently failed to redevelop pursuant to that master plan, then the cause of action would not have accrued in 2008, which is the argument on appeal here, but it would have accrued at some time later, and then that later time of breach is not on the face of the complaint.
Counsel, if I may ask, so just for clarification, your cause of action is a breach of contract
Yes, Your Honor.
between your client and the Fair Association.
Yes, Your Honor.
And as part of your complaint, you pled the existence of the contract, correct?
Yes, Your Honor.
Did you also plead in reading the contract for me, unlike Law School 101, you have a contract, you have a breach, and you have damages. But in your case, I believe the unique scenario is it's not just one condition that needs to be met as part of the contract. You have many conditions that need to be met as a part of the contract, and those portions of the contract become mature, so to speak, along different parts of the business agreement, correct? You have the master plan that is obviously the first deadline and really the only secure deadline that I could see.
Yes, Your Honor.
Specifically spelled out by the contract.
Yes, Your Honor.
And then you have other things, but the ultimate point behind the contract is to develop the property. Is that correct?
Yes, Your Honor.
But there's no deadline to actually develop the property by a drop-dead deadline. Is that correct?
Not necessarily, Your Honor. The term of the contract is defined in, I think it's paragraph 12 of the performance agreement, where it says the contract continues until the, quote, substantial redevelopment of the property. So with county approval. So until the property is fully developed and approved by the county, this contract is still in place, which results in this continuing obligation to redevelop it until that time of the termination of the contract.
But there is no deadline as far as the ultimate development of the property that's included in the terms of the contract. Is that correct?
Correct, Your Honor. And you can see that from some of the different provisions in the contract about the ability to change timelines, or I think the main obligation is dependent on the fair's ability to financially afford the redevelop and finance those improvements. So, and I've made this argument in my reply brief, where the time requirement to create a master plan by a date certain was a minor obligation, whereas the material breach of the contract is the redevelopment of that property.
Does the redevelopment occur, sorry, Dave Wallace.
That's okay.
Absent a master plan?
Could the redevelopment occur absent a master plan? I think the contract implies that the redevelopment would occur according to a master plan that's created by a date certain. But
Is a master plan required for redevelopment such as this one?
Could you waive it?
I think realistically the parties could waive anything, but those facts would be outside the four corners of the complaint, so the statute of limitations defense wouldn't apply to that.
Well, let me ask this. I think that's along the line with Judge Harris and Judge Wallace are asking. So the master plan under the contract was due by December 31, 2008. Your position is really, that's part and parcel of the agreement, but the big deal is we gave you property so you guys would develop it. We've given you the property, you've not developed it. We're now 15, however many years down the road, and it hasn't done it. So is there any statute, could you have, the county have filed suit in 2040 and say, we never did get a master plan in 2008, they never redeveloped it, we gave them this property, I don't know what our predecessor commissioners have been doing for all these years, but it's time to Fisher cut date, so we're gonna file suit in 2040 to make to get our property back if you guys aren't gonna develop it. Is there, I guess I'm roundabout saying, is there no statute of limitations vis-a-vis the actual substantial development of the fairground property?
Well, there would be a statute of limitations, but because it's a continuing obligation, you can't sever it into different installment payments, then that statute of limitations doesn't trigger until either the last breach or the termination of the contract as a whole. So I think the Allapattah court kind of described it best, where you have to first make the factual finding that the contract itself is severable or continuing. If it's a continuing obligation, then the statute of limitations does not begin to accrue until the termination of that whole contract, essentially.
The completion of the whole contract, or the lack of completion of the contract.
Right, and that's what I think, if you look at the Dolgen Corp case, it talks about some of the facts that could be considered to make that threshold determination of severability versus a continuing obligation. And it says that if a contract, you have to look at whether there are any breaches within the statute of limitations period. So here, whether there is a failure to redevelop the fairgrounds in the past 5 years. And then the second fact that needs to
come up that 5-year time period.
For actions on a written instrument. And I think
Okay, but you don't even have a 5-year, when you were proposing your response there, when you were formulating your response, you said, until the final breach takes place. Well, I go to, okay, well, what is the furthest out purpose of this contract when the parties will say, okay, you have completed your side, I've completed my side, we're done. You don't even have a final date as the way this contract is drafted for when ultimately there would be a drop dead. Okay, we have a completed contract at this time, or we have a breach of contract. There's no date that's in any way, shape, or form written into this contract for that actual date.
You have no trigger date for when it happens.
Um,
For the material breach you're talking about, you haven't developed it.
It has not occurred yet, is the county's argument, Your Honors. But so there would have to be facts
How does
outside.
it occur? I mean, unless the fair says, I know we had this agreement that we executed back in 2005 or whenever we executed it, and we've never developed the property. Just so you guys are clear of the county commission, we're never going to develop the property. Have a nice day. We certainly appreciate you giving us the property. I guess then that would be the trigger date. I guess that would make it easier for you
Yes, Your Honor.
or your side.
Yes, Your Honor. And similarly, I think that principle kind of
But we don't
ties
have that
into.
here.
I think that principle ties into another factual circumstance that could result in triggering the statute of limitations. That is finding that the construction has been abandoned, right? But that would be outside the four corners of the complaint. If there's a date certain that affirmatively, based on reasonableness, and if you look at the Hicks versus Keebler case, the reasonableness as to the time of performance of a contract is a factual issue that can't be addressed in a motion to
Well,
dismiss.
you do have somewhat of a definitive date here, though, in the sense that didn't the fair get a line of credit and, in essence, a mortgage on the property without your side's consent, and the agreement says you can't do that without county consent. So once they did that, that is a directly tangible, like you're not paying a promise right now. You didn't pay it on that day. Here they said, we've now gotten a lien on the property. You guys can ask for it, but we think it's our property at this point, so have a nice day. So, and that occurred within 5 years of you filing the lawsuit.
Yes, Your Honor, and I think the argument could.
Continuing obligation not to do that without your consent.
Yes, Your Honor, and that's the way that the county looks at the agreement. Is the main obligation is to redevelop. Everything else is related to that. So it creates kind of an absurd result if you try and sever those obligations from one another and create different statute of limitations from each portion.
And they've been using the property for the fair subsequent to the date the master plan was due.
Yes, Your Honor.
So, I mean, they've had the benefit of a piece of property that the county has given to them in anticipation of it being developed, and they just haven't developed it, and you guys don't see that happening, so you brought the lawsuit, and you're your position is whether we win or lose, we shouldn't lose on a motion to dismiss because all things have to be construed in your favor, and including any possible reply to the affirmative defense that may raise factual defenses. That should be tried on a factual thing and not a matter of law. Isn't that your position?
Yes, Your Honor, and that's why it was an abuse of discretion for the trial court to dismiss the complaint with prejudice, because it prevented the county from being able to raise these additional facts to, as Trawick says in the Price versus cited in the Price v. Morgan case, 3 ineffective attempts to state a cause of action is generally going to be enough for dismissal
Well,
with
let me
prejudice.
ask this, and just, you may not be in the appellate world as much as we are, obviously, but one of our buzzwords nowadays is preservation. We beat that horse, ironically being on cow type of horses, we beat that horse to dead drum, but you're saying that you're arguing that the trial judge abused its discretion by not giving you another opportunity to amend your complaint. Prior to the being raised in the motion for rehearing, was that presented to the court as an option below?
Prior to the motion for rehearing?
Yes.
No, but so there was the motion to dismiss, and there was a hearing on the motion to dismiss, and the trial court judge took it under advisement. So the parties weren't clear about whether or not it
I know,
would
but
be.
my point, and trust me, this is from experience that we have in our discussions with our colleagues. Was it postured in a sense saying, look, Judge, we don't think there's merit to the motion to dismiss, but this is still early on. If you granted, we would like leave to amend because we think we can add additional facts that would survive the motion to dismiss on the complaint as presently pled.
No, Your Honor, not at the hearing on the motion to
Does that
dismiss.
become problematic for you from an appellate standpoint that it's unpreserved?
No, because there was a motion for rehearing, giving the trial court the opportunity
But I
to.
mean, isn't there a body of law that says you can't raise an issue for the first time on a motion for rehearing?
Not that I'm aware of, Your Honor. I think the case law that I'm familiar with is where the error wasn't preserved was when there was no motion for rehearing filed whatsoever. In that case, I think this court has repeatedly held you haven't preserved your error, you don't have appellate jurisdiction.
Well, we have jurisdiction, you just haven't. You're not going to win.
Yes, Your Honor. But in this case, the county did bring the abuse of discretion to the trial court's attention, and the trial court decided to deny that motion for rehearing, and that led us to this appeal here today.
Did the motion to dismiss ask for dismissal of prejudice?
I think so. I think it was a motion to dismiss the action with prejudice was how it was phrased.
So did the issue of prejudice or without prejudice come up at that hearing?
No, Your Honor, not until the judge actually entered the order. I mean, both parties submitted competing proposed orders, but then there was no knowledge about whether it was going to be granted or denied until the judge actually entered the order, which led to the motion for rehearing, the denial of that motion, and then this appeal.
But knowing the request would be a dismissal with prejudice, you had the opportunity, the county had the opportunity to argue that at that initial hearing, right? That if you do dismiss, it should be without prejudice.
It wasn't raised at the hearing because, I mean, as I've talked about, there's 11 cases that say you can't dismiss with prejudice at the first challenge. You have to give at least an opportunity to change it. And those facts were then thereafter made aware to the trial court to basically rehear the case and either require a second amended complaint or...
Excuse me, Counsel. The point of the motion for rehearing is you overlooked something, Judge, when you ruled. How does a judge overlook something that's not brought to her or his attention in the course of the actual hearing or in the filings leading up to the hearing? I think that's kind of what the concern that's being raised vis-a-vis preservation, saying, we're a correction of the trial court. That's what we, and if the trial court's not given the opportunity to do that, why does that become reversible error? I mean, we understand the body of law. If you had asked for it and the judge says, no, you can never do it, it's your first complaint, have a nice day, case over, another one off my docket. but that's not really the posture per se, well, as to this limited issue we're talking about right now.
I mean, respectfully, that is the posture because the trial judge didn't consider argument at the motion to dismiss hearing about dismissal with prejudice or without, even though it was requested by the Fair Association. And then in the rehearing, the county raised the argument, hey, you didn't consider the prejudice versus non-prejudice or without prejudice. So therefore, here's the law as to why you can't dismiss with prejudice and you should give us another chance. And she denied that motion for rehearing.
And so you have 3 minutes left, reserve.
Yes, Your Honor.
Good morning, Your Honors. My name is Joe Mason, McGee and Mason, PA, in Brooksville, representing the Fair Association, the appellee in this matter. Just a brief thumbnail summary. There are 2 contracts involved. They're interrelated. The Memorandum of Agreement attaches and incorporates the performance agreement. The Memorandum of Agreement specifically says that the attached performance agreement has and specifies certain specific steps in the performance agreement. Those steps are 90 days after signing the contracts, sign an agreement with somebody, some planner, some agency, some consultant, to prepare the master plan. That wasn't done. The next step is on or before December 31, 08, present.
Does the record indicate why y'all didn't do that?
Judge, I'm a latecomer to these issues, and I have no idea.
So the record doesn't show.
The record does not show. No, sir. No, it does not. But the next step was to prepare and submit. The word submit is important. Submit the master plan to the county commission for its review and approval. And only after the master plan has been approved by the county commission can the next and final step be taken, and that is the redevelopment of the fairgrounds. In other words, redevelopment cannot occur unless the master plan is approved by the county. Has to receive it, has to be prepared, the county has to receive it, and then approve it before
Can't they waive that?
Pardon me?
Can't they waive that?
They could, but they didn't.
Well, but that's a factual thing, isn't it?
Judge, I don't think it would be a factual issue simply because there's never been any communication from the county to the Fair Association that, we can forget about the master plan.
That's factual, though. You might be able to show that and win at trial if that's an argument. But I mean, you just saying that didn't happen. You're telling me a fact of what never happened during the 14 years, and that kind of wouldn't that defeat the theory of granting a motion to dismiss based on a statute of limitations, which is historically an affirmative defense? Is that right?
Well, Judge, the county had the opportunity to do that, and the county had the opportunity to plead. The county had the opportunity to tell the trial court, we can plead in a second amended complaint, we can plead that we waived it.
That's what he's saying. He said he wants a chance to have an amended complaint.
But he never suggested to the trial court that might be one of his pleadings. And bear in mind, it has to be a good faith pleading.
I don't know one way or another, but I mean, we're talking about a motion to dismiss. You have to basically, the allegations of the complaint have to be conclusively negated by the statute of limitation, and also the ability for them to plead any type of an avoidance, a reply to your affirmative defense to say, yeah, they've raised the statute of limitations, but Judge, here's the factual basis why that's not persuasive in the case before you. And so you have to meet that burden to win on a motion to dismiss and to prevail on appeal. And so I think that's somewhat the argument that they're saying, is that it's not that clear cut because there's both a definitive breach date, you didn't do it by December 31, 2008, but there are other continuing obligations that are not within the statute of limitations defense, and therefore we should be able to pursue that.
Well, as this court had just raised with counsel, that issue was not preserved at the trial court. That issue should have been raised at the motion to dismiss hearing.
Did you argue that in your answer brief?
No, Judge, I didn't, because the issue had never been raised.
So you like what we said today? That's pretty old.
Indeed, the issue cannot first be raised. The court was correct. The issue cannot first be raised at a motion for rehearing.
Well, are we supposed to also disregard your argument as far as your failure to argue that in your answer brief here today? Why should we allow you to argue that point when you clearly saw it raised in the initial brief by the appellant?
I'm sorry, so which issue?
The same issue as far as the preservation issue. Never responded to that in your answer brief, correct?
I did in my answer brief note that there was not a request for a leave to file a second amended complaint filed. Yes, I did to that extent. There was never a request for leave to file.
Mr. Mason, has your client during any time of the existence of this contract met any of the performance obligations that were enumerated?
No, Judge, they did not.
Okay, that even there's a continuing obligation, at least as I read it as well, to notify the county if there are any changes to the governing board. Is that correct?
Well, there is, Judge, and in fact,
There were changes that were made and they were not notified of the changes.
County Commissioner is a member of the, appointed by the County Commission. A County Commissioner is a member of the Fair Board and reports back to the County Commission on all such matters.
But the contract didn't excuse your client's obligation to notify the County Commission despite the existence of a member of the board on the board. Is that correct?
But there were occasions, and this is totally outside of the record, but I will tell the court that there were occasions when members, representatives of the Fair Association did appear before the County Commission and provide information.
Well, and you're going to rely upon that, right, for explanation to the trial court if we go beyond the pleading stage of this case. Obviously, that will become relevant, and that's also, I think, as you just mentioned, outside of the four corners of the contract. That would be very relevant to discovery. That would be very relevant to if this case does present to an issue of motion for summary judgment prior to trial. Is that correct?
But Judge, we first got to get there. And to get there, you've got to get beyond the fact that nothing in that contract, no obligation of the Fair Association that might arise under that contract matures until the county approves a master plan. Now, there was talk
Well, I think your argument at this point is all of that is moot because the county did not move within the confines of the date of the breach, which you're saying is the master plan. The statute of limitations has run with regard to that.
that is indeed our position. Your
So
Honor.
if we take your position to its ultimate finality, where do the parties stand? Am I correct that ultimately the parties will stand with your client basically being in possession of the fairgrounds property free and clear without any obligation, either performance or otherwise, under the pre-existing contract?
The contract, no obligations in that contract matured until the master plan was approved. So, yes, Your Honor, that would be the ultimate result. The Fair Association and the county can work together in the future to get a redevelopment done, but the old contract,
Well, why would you?
Pardon me?
Why would you?
Well,
I mean, in other words, what Judge Wallace is saying is, you got a big piece of property now, and the county can't get their property back, and you're saying, well, now that we've got their property, we're happy to work with them. What do you need to work with the county for? Why can't you just develop, I mean, obviously with its zoning requirements on that.
Well, one example, and it's raised in one of the filings by the county. The county did participate in trying to get a grant from the state with us. Well, the county and the fair could look to get grants, state and federal money for the redevelopment. That's just one thing, but let me mention materiality.
Let's assume we went to the trial took place here. Could the county not put forth evidence that says, I know there was a master plan that was supposed to be given to us by December 31, 2008, and they didn't do that, and you don't dispute that you didn't do that. But during the next 10 to 12 years after that, we worked together, made efforts to try to get this thing going, to help you guys redevelop the property, and finally it became apparent to us as the county that you guys weren't acting in the best faith of wanting to do that, and that's why we filed a lawsuit. Why can't they present that evidence, and the trier of fact may disregard their evidence because they have the burden of proof? Why can't they do that?
The only communication pleaded by the county is a communication by the Fair Association in 2014, January 2014, after the expiration of the statute in 2013. And we talk about materiality. It doesn't matter whether the breach was a material breach or not. Let's assume that there was a grant sitting out there with a drop dead hard deadline of December 31, 08, that if we didn't get the master plan presented by then, the grant goes away. That would be a material breach, because then the grant is gone. You can't redevelop without the grant money.
In our situation, contract does not impose such a drop dead date.
No, sir, I didn't. I just suggested that as a
Does the contract
hypothetical.
make that December 1st date a drop dead date?
No, sir, it was not.
Is time of the essence in the contract?
That's what I was getting into.
Does the contract provide the time is of the essence?
Contract does not provide.
Would it have made a difference?
I don't think so, Judge. And what we have here, time is of the essence, would be the county requiring the Fair Association to respond timely. But let's take the situation that we actually have. The master plan was not presented to the county by December 31, 08. The county has, within the contracts itself, specific performance is specified as a remedy for any breach, major, minor, material, non-material.
They can also waive any breach, right? Does the contract also say the county can waive a breach?
There was no indication that a breach was waived.
So that could be fixed by amending the pleadings.
Well, the breach occurred on December 31, 08. The county could have required the master plan to be prepared, simply file a complaint for specific performance, which is specifically allowed in the agreement. The county waited more than the 5-year statute. As a matter of fact, specific performance has a 1 year, or it's a 2 years. I forget, 1 or 2 years.
1 year.
Statute. They waited beyond the specific performance. They waited beyond contract statute of limitations. They waited for 13 years, 8 years beyond the statute, before they even blinked their eye and said anything.
I mean, at the end of the
Let's assume
at the end of the day, I mean, basically this is a contract that says, we, the county, will give you this piece of property as long as you guys redevelop this property in some fashion that's acceptable to both sides. I mean, that's the core of what your contract is.
That's correct.
And there's a master plan, like, okay, just like they probably didn't build this building here without an architectural plan. Well, I know they did because I was there. But I mean, all right, but so they didn't. So if there was a date in the contract that says, look, we're giving you this property, but you got to finish this property by December 31, 2014, and if you don't, then the meter starts running. That's the drop dead date. But there isn't that drop dead date vis-a-vis the core purpose of the contract here. And they're saying there's continuing obligations, that is a factual dispute, that they may lose at trial, but they believe they have the right to at least present it to the finder of fact. And that's
Well,
where they think it's problematic.
well, if you take the
That's what
county,
the trial judge did, and you could probably glean from some of the questions that some of us do too.
well, if you take the county's position to its logical extreme, there is never, ever an end date on their opportunity to file this litigation. The contract terminates when both parties are satisfied. Well, if both parties are satisfied, there's never a breach. Therefore, a statute of limitations period can never start running.
So it cuts both ways. I mean, you guys could be, I guess theoretically, under your argument, you could say, okay, we've waited past the 5 years. It's now January 1, 2014. We got them. Here's our letter. We're never going to build this thing. We're never going to do it. And you guys slept on your rights. So we now have a free piece of property. Have a nice day. And I guess that would be the anticipatory breach if we have no actual breach date.
Yeah.
But then that would start the meter running. So is that the right resolution here?
Well, Judge, far be it from me to defend my client's lack of diligence. They were not my client at the time. But far be it from me.
Here's the factual scenario that can develop from what your argument is.
Well, but the point is that the statute of limitations is clearly violated. This court,
you use those kind of words to appellate courts.
well, this court's, I understand. I'll retract clear.
It's arguably clear.
Arguably, this court's opinion in Calif, which was cited by both the county and the fair, essentially says that it's not an abuse of discretion to dismiss with prejudice when the start date of the statute is clearly shown in the pleadings. The start date of the statute is clearly shown in the
Let
pleadings.
me ask from a timing standpoint. This is an amended complaint. Was the original complaint, was the amended complaint filed before there was a response from the fair?
There was
In other words, they file it, they say, oh my goodness, we have the wrong date, so they amend it before you guys even get served or file a response?
No, we were served. There was some issues regarding service. There was motions to quash. That was all resolved.
Okay, so they amended it.
And then they amended.
Okay,
And
so-
then I filed the motion.
Is there not a case in the Supreme Court called Bokenberger that basically says that it's an error of law to not give leave to amend an amended complaint when there's been no prior dismissal from a...
Well, as I understand, Boca sanctioned an attorney for arguing the opposite to the Supreme Court. But yes, there's no question that...
Basically, you can't dismiss the first effort without... Even if it never comes to fruition, doesn't the Supreme Court say you got to get somebody at least one substantive effort to amend?
Judge, I don't believe so. The cases clearly say that if the statute of limitations is evident on the face of the complaint, that it can be raised in a motion to dismiss,
Right.
and that's what I did. The start date of the statute was December 31, 08. The Calif case of this court, cited by both parties, clearly says that if the start date is set forth in or discernible from the complaint itself, that the statute can be raised on a motion to dismiss. And if in many cases, in fact in Boca, the Supreme Court essentially said that if the statute is clear on its face in the four corners of the complaint, that it's expired, that a motion to dismiss and a dismissal with prejudice is available.
Mr. Mason, you would agree with me that there is a substantial body of case law in the state of Florida that motions to amend and amendments are liberally given
Correct.
unless to do so would result in futility. Is that correct?
That's correct. And our point is that this is, even if the county had requested leave to amend, I would have argued, I may or may not have won the argument, I would have argued, however, that it would be futile because you can't plead different dates. You can't plead a different date of the requirement to present the master plan. You can't plead a different date of the filing of the original complaint, not the amended complaint, the original complaint. Those two dates are fixed, in fact, fixed in for eternity, and there's no point in allowing an attempt to amend. It would be futile since those dates cannot be changed. It would not be a good faith pleading if those dates were changed in an amended pleading. I see my red lights coming on. We appreciate the time, Your Honors. We believe that, as I said, I don't defend my client's lack of diligence, but it is a very clear issue of law. The county didn't protect itself. Thank you much.
Thank you. Okay, Mr. Zimmer.
Thank you, Your Honors.
You got 2:57 on the clock.
Yes, Your Honor. Just a few things I'd like to address in my rebuttal is if this court were to accept the arguments made by the Fair Association, I think it would lead to an absurd result where essentially you're forfeiting the entire contract, which is what I think Your Honors were getting at with some of your questioning, where...
Of course, you could have avoided that by just filing suit in 2009, right?
Possibly.
Well, you wouldn't be having a statute of limitations discussion.
True, Your Honor. Then that's long before I ever worked at the
Well,
county,
all right.
or before I was a lawyer.
Filed something and saved you having to be here right now, right?
Yes, Your Honor.
I think the analogy for both of you is, as lawyers, I analogize it to airplanes. You don't build them, you just fly them, right?
Yes, Your Honor. So it creates this absurd result where you can't enforce the creation of a master plan, but theoretically you can compel redevelopment of the fairgrounds, or the county loses property it had prior to the date of the contract. But I think what's really important is the provision in the performance agreement that the parties are not waiving any failure to raise a breach at the time of breach of any continuing breach during the term of the contract. And I think it's paragraph 12 of the performance agreement. So essentially, the Fair Association has waived already the argument that it's making here today that the county didn't raise the problem in 2008 or at some point during the term of the contract. So now it's been too long and you can't ever raise it.
But the flip side of that is the absurdity of the contract is arguably you're never going to have a drop dead statute of limitations death knell to this agreement, because you can say it's all determined upon when you redevelop or you develop the property, and your client can say, you know, we've never come to that point where we actually think that you have fully redeveloped it. So whenever it's convenient for your client is when they can choose. We can just take our own sweet time to decide whether or not to announce or make the allegation that there's been a breach, correct?
Yes, Your Honor, but that becomes a factual issue. So when is that reasonable time for, either the county waiting too long or the Fair Association waiting too long?
So could Latches bar it then? I mean, in other words, you could file suit in 2050 saying, well, you never did redevelop, so you should have had that master plan in 42 years ago, but you didn't. But you had these continuing obligations, so now we're filing suit, which would then be problematic to the fairground because presumably most of the people involved in the negotiations, et cetera, may have passed on and the witnesses are all gone.
I think hypothetically that argument could be raised, but it'd be a factual issue. So it would depend on the facts and the trier of fact to make those determinations.
All right, counsel, your meters are on here.
Thank you, Your Honor.
All right, gentlemen, why don't we start, Mr. Benda? You talk to the students here, tell them about yourself. What did assistant county attorneys do? What did you do to prepare for this case? How long you been a lawyer?